There you go. And good morning, welcome. It is, oh my God, it's March 29th. Is that possible? Yes, it's possible. You are in Senate Economic Development, Housing and General Affairs. And we are continuing our work on data privacy, which is a huge bill and underscores a lot of our other work on AI and its code. And so we are beginning to address the work that our House colleagues have done and that we are going to continue to do. So we have with us a lot of advocates. Our chair, Keisha Romp-Hinsdale, is feeling under the weather and is participating by Zoom, but is going to be we're allowing her to be pretty ill, so that's okay. We're here. And Keisha, when you feel you want to, please chime in or wave, or we'll bring you in. And
thank you.
Yeah, and John, I think we're going to start with you and Monique, basically. Monique, do you want to join us here at the table? Come join us. I'd love to have you. Come join us because you're as an active participant here. So I think, yep, it's up there. Thank you, John, for making it as big as possible.
We try to do even better.
For your blind vice chair.
Hopefully that's okay.
Great, terrific. So we're gonna give the floor to you two for the moment. And if people feel they need to contribute with whatever section we're on, please just let me know. I can't see you, Jamie, so you'll have to do something else like fit in here. Anyway, so floor is yours.
Great. So John Gray, Office of Legislative Counsel. I don't know if Representative Priestley also wants to.
Representative Priestley.
So I'm happy to jump in where I believe we left off, which was, I think we went through the applicability section, but I could go through it again. The other thing that I could do is
remind us we're on draft 9.1.
9.1, this is what's received from the House, and this is on the very bottom of page 15, top of page 16. What I could do, if you're interested, is just to give like a quick overview of the whole bill before we proceed with the rest.
I think that would be terrific because some of us are new to the bill. Some of us aren't, and if that would be great, and if you would also just summarize the work that we have begun already on the definitions, because I think there are 15 pages of definitions that we just went through.
Sure. So we haven't on definitions. We haven't at this point updated. There is an attempt to look at these together with S289, the Kids Code bill that you guys passed out. I put together a chart which I haven't gone over with anyone, but I have here of comparisons. Other folks have been looking at this as well. So there's things to think about, but sort of a separate conversation. At this point, the draft is as it is.
Right.
And we're just going through what's the House version. Okay. As far as the bill as a whole, oh, sorry, was there?
No, I mean, give us your overview. I think
I'm
that's
just hearing voices.
Well,
so,
you never know.
I know. This was
Many have passed through this road. We have no idea what we're channeling here.
So who does this act apply to? This is a person who either conducts business in Vermont or produces products or services targeted to Vermonters and control or process the personal data of at least 6,500 Vermonters. So that's that 1% figure we talked about last time, or at least 3,250, meaning 0.5%, and they derive more than 20% of their revenue from data sales. What does it do for Vermonters? It grants a set of rights with respect to their personal data. So that's confirmation and access. They can reach out and find out what information, what personal data these entities have. They can access that data. They have the right of notice of third parties receiving that personal data. So they'll be aware of what parties out there are getting that information. To correct the data, sometimes information that gets out there is incorrect. So you have the right to correct data. You have the right to request deletion, the right to delete that data. Data portability, meaning that you can access that data when you receive it in a form from a controller or processor, in a form that allows you to, if you wanted to transfer it to someone else, for instance, or it's meant to be in a usable format. Going on with my Zoom. And you lastly have the right to opt out of a series of what are considered more sensitive areas. So that's targeted advertising, sale of data, and profiling to make significant decisions. And we talked about the significant decisions piece. I'm using a condensed version of that term. Basically, it's when people are making automatic decisions on the basis of certain elements.
Did you mean to unshare your
No, something's going on with my
internet?
Zoom.
It's the bloggers syndrome. You know, sorry, you were alluding to them earlier here. You know, no.
Hopefully I will click back in. I will say that for these purposes, it's okay if I'm not screen sharing at this very moment.
Right,
But
but
if
you're
it,
giving us the overview.
but if it doesn't come back in a few minutes, it will be a little bit difficult. So those significant decisions, you can opt out of automatic processing that happens to make decisions related to, say, housing, financing. The idea is to try to pick up instances where you're being kicked out of really important things in your life, and you don't have control over that. So it's meant to grant you some autonomy there. Let's see if I can screen share.
That's an interesting concept, significant decisions. Is that a defined term?
Yes, and I'll just do that right now. Let me scroll up so you can see.
And with all this, with all these opportunities that consumers are going to have. I assume there are requirements in the bill that make it relatively simple and
Yes,
easy and clear on how
yes,
to do all
and
of it.
I'll come to that shortly. But just because we're on this significant effects piece, this is the top of page 5, and if you look on the screen, I have the definition up for decisions that produce legal or similarly significant effects concerning the consumer. These are decisions made by the controller that result in the provision or denial by the controller of financial or lending services, housing, insurance, education, welfare opportunity, criminal justice, employment opportunities, healthcare services, or access to essential goods or services. So these are the sets of decisions that we're talking about. The other piece that you're going to want to know is the definition of profiling, which is down on this is subdivision 40 on page 10. That's any form of automated processing performed on personal data to evaluate, analyze, or predict personal aspects related to an identified or identifiable individual's economic situation, health, personal preferences, interests, reliability, behavior, location, or movements. So that's automated processing on their data that allows them to evaluate, make a judgment about that individual's these sets of factors, economic situation.
Or maybe not a judgment, but maybe an equation.
Right, exactly, it's automated, and that's a key part of the
So it's
definition.
not a judgment.
Right, or it could be automated and a judgment where they say, this person doesn't qualify for a loan, pick them out.
That's the kind of thing that it's meant to.
Exactly. I mean, there's some.
Yeah, but that's a
Decision.
judgment.
Right.
Yeah,
Well,
I mean, we can,
I think that's more of like a philosophical conversation.
yeah, it is, sorry.
Yeah.
So those are the sets of rights, and just to go over those rights again, that's confirmation and access, notice of third parties, correction, deletion, data portability, and opt out of those targeted advertising, sales of data, and profiling to make significant decisions. So that's the set of rights that are granted under the Act. Consumer health data is subject to additional protections. You'll see when we get to the language, I'm not going to go too much into detail at this point, but it talks about persons generally rather than controllers, and it's related to employees and the like. But there's duties of confidentiality that attach, no sale without consent of consumer health data, and a prohibition on geofences. So trying to get at people tracking folks who are trying to go to mental health facilities, reproductive and sexual health facilities, gender affirming care facilities, healthcare facilities, generally trying to prohibit geofencing, which is establishing a virtual boundary within a certain perimeter. I think it's 1,850 feet in this draft. Trying to stop that from happening for consumer health data purposes.
We'll have a question on, do you want questions now or?
I'd let John, let's let
Okay,
John finish.
okay, I got it.
And I
Right,
think-
Right, it's my question.
Yeah, and this is all just
Yeah.
high level overview at this point. So
And would you
we'll get to
supply
that.
us with that high level overview summary? 'Cause
I can do that. I would want to.
not this
Yeah.
second, but it would be helpful, I think, for all.
I think
Oh,
also the section by section,
Could do that. I would like to do a little cleanup, and this one I like rushed out this morning,
So that's great. That's
Um,
terrific.
so I would want to. So additional protections for consumer health data, and it's worth noting that sensitive data as well as a special kind of data that we care about. We went through those sets of categories. There's many categories of information that fall into that. For sensitive data, we need consent for processing of that data, disclosure in a privacy notice, which is part of that accessible, understandable piece that's going to go to consumers, and processing of sensitive data constitutes what's called a heightened risk of harm to a consumer and will trigger certain data protection assessments, which is something that we'll come to that allows for companies to track what's going on with their processing. And then in enforcement actions, there's meant to be provisions for those data protection assessments to be relayed to the AG's office, and they can look over the data protection assessments. Unlike some of you may have heard about data protection assessments in the kids code context. I know that there was some concern about prior restraints. There may have been other discussions as well. I will note there are no prior restraint concerns here because the data protection assessments don't have to be in advance of any particular activity. You can do the activities, you just need to conduct data protection assessments, and we'll come to those sections. But I know that this was something you guys were thinking about in the kids code context. I will note data protection assessments are done in these comprehensive data privacy regimes in states across the country. So this is not unique to what Vermont is doing here. So that's what it does for Vermonters simply. It also imposes a set of obligations on the controllers. So that's the entities that are subject to this act. They must provide a privacy notice that sets out the purposes of the collection and processing of that data. Process data only as reasonably necessary for those purposes. There's slight complications to this, but basically a data minimization principle. They're only supposed to collect, process, use that exactly. And to the extent that they go beyond that, it's meant to be for purposes that are either sort of essential to and compatible with that disclosed purpose, or obtain consent for something beyond those purposes, in which case then you would have noticed that that's what's happening. Controllers are obligated to establish data security practices. So this doesn't only relate to obligations directly to consumers and how they transfer that data or what they do with the data. It also has to do with establishing security practices so they're maintaining that information. They have to provide consumers a way to revoke consent to processing and to submit requests to exercise those rights. And those pieces are meant to be as easy to access as the initial mechanism. So they're not meant to be able to, controllers aren't meant to be able to hide behind obscure forms that prevent folks from understanding that they can exercise their consumer rights. Controllers are obligated to obtain consent to process personal data, again, for those data minimization pieces that's not reasonably necessary for or compatible with purposes disclosed in the privacy notice. They have to obtain consent to process sensitive data. And they have to obtain consent to process personal data for targeted advertising or profiling to make those significant decisions or sell data. So those are those three, again, heightened forms. They have to conduct data protection assessments for each processing activity that presents a heightened risk of harm to consumers. The content of what that is will be spelled out when we come to that section. They have to take reasonable measures to ensure that de-identified data cannot be associated with any individual. So you can think of that along with establishing data security practices. And they have to monitor compliance with contractual commitments for that pseudonymous and de-identified data. Controllers that offer, and this will be directly relevant or on the same subject matter that you were considering when you were looking at kids codes. Controllers that offer online services, products, or features to a consumer that they know or willfully disregard is a minor have additional obligations. We'll come to those in section 2420. I didn't have time, unfortunately, to spell those out in this doc this morning.
It's okay. Well, and we've dealt with a lot of them with kids codes.
Yeah, and
Not all. but
when we
some.
get into that conversation, I have a whole markup and thoughts on kids code stuff, and we can talk about, we can talk about that when we come to that. Processors, so those are the folks who are processing personal data at the direction and under the instruction of those controllers, and they're obligated to follow those instructions. To the extent that they stop following them, they are deemed a controller and are therefore subject to all the obligations that we just talked about. But processors acting within their roles as processors are required to adhere to controllers' instructions and assist that controller in meeting its obligations, including in facilitating responses to consumer requests and assist with data protection assessments and the like. They also have to enter into a contract with the controller governing that processing, establishing a duty of confidentiality, and requiring deletion or return of personal data at the controller's direction or at the end of services. So when their services end, they're meant to delete or return that personal data. Lastly, and again, this is just a quick high-level overview, how are the protections enforced? There's both private right of action and AG enforcement. It's worth noting as well that there's some concurrent enforcement authority with DFR related to DFR licensed entities, and that's something that we'll come to, certainly not today, but eventually we will get to that. there's also language at the end, the separate chapter dealing with data brokers, which we'll get to, but just for now, this is overview of the new Vermont Data Privacy Act, but we will come to the data broker language, which is.
And the data broker like work, I assume, builds on what we've already done.
It's amending existing subchapters. It's in a distinct, different subchapter.
Right.
And it's modifying, it's essentially requiring the provision of opt-outs for data brokers. In compliance with certain deletion requests and the like. There's also some modifications to. I think civil penalties is what we included in there. But we'll come to that. With that, I can jump into.
Okay,
Draft.
with that, we can go to a few questions on your overview.
Sure.
Yeah, just one question that's, I have more than one, but one is most important because we're looking at a cable and streaming franchise bill right now. It's up for third reading.
Yeah, came out of finance.
And are those companies subject to this sort of restriction?
There's, so we'll get to the exemption section. Off the top of my head, there's nothing that. I can't give a definitive answer.
Well,
I don't know if it fits into one of
let
the
me
buckets,
say-
but
I believe that they should be subject to this. Because
Well, I-
they collect a ton of data.
can you explain more what the, we're
Sure.
talking about like Netflix?
Like-
what do we-
Like cable companies and streaming companies, Roku, Comcast, Netflix, they know what we watch. And what we watch is data. And that data can be used, and I believe it is being used to market items.
Sure.
And it's personal too. So I really hope this includes that.
Well, the library can't reveal what you read or what books you take out,
Right, but
so,
that's,
well, we're
intentional.
working on an amendment.
yeah,
Says they can't use, that we are gonna tax the money they use from selling your data, if they are selling your data.
the libraries.
No.
No, the streaming company.
Right. No, I
Yeah,
understand,
yeah.
but I'm just wondering if there's any. We are looking at franchise fees now, so that's a little bit different. But, I mean, yesterday I asked a question and we'll see if
It's a good question.
and I think it's being followed up on about revenue that those companies get from selling our data, public's data. Whether or not that revenue is in one of the categories that are going to be subject to
Is it
a
captured?
franchise.
Yeah, is it captured by this? bill?
Right.
So I can give you my in the seat answer, and we will shortly come to the exemptions and can walk through and see if it would appear to fit into any bucket. My initial response is, I don't think that it would be exempted from this act, the way that it would be. So, to explain what that is, there are data level exemptions in the exemption section, and there are some entity level exemptions in the exemption section. So the data level exemptions relate to particular kinds of data that are processed in particular ways or done in accordance with, say, independent privacy regimes like HIPAA, COPPA, something like that. For those, the exemptions would be specific to data, so it's possible that an entity would have some data subject to the act and other data that wouldn't be. We also have entity level exemptions, which means kind of wholesale exemptions. If you're one of these folks, you're not subject to this act. So what I will say is, there is no entity level exemption that I am aware of
Okay.
that would exempt this kind of entity. That said, I don't know if Netflix or these other companies may be organized in different ways that allow them to, they're not.
Well,
I don't think they fall into the entity level exemption bucket, but we can come to that, and the question would ride on if there are odd features of Netflix's structuring that I'm unaware of, basically. Like, I'm just assuming that what Netflix is a company that's offering broadcasting streaming services. It's not a financial services institution, but sometimes people are organized in odd ways and you can run into.
yeah,
They did ask me if I would like to post to Facebook that I was watching Thomas the Tank Train.
Yeah.
I said, no, thank you, that was my
Yeah.
grandson.
yeah, so that's kids code, actually.
There's nothing wrong
That's-
with. the trend.
No, there
Yeah.
is not.
We loved her.
Right,
I've been
no.
very happy for a long time.
They need to be regulated. They're use of our data needs to be regulated.
So
So
I will
let's
say
just
that-
make sure we.
You think it
Yeah.
I will say this act is trying to target exactly that kind of thing.
Okay.
I didn't wanna overcommit to saying, oh, maybe Netflix is organized in some way that I'm unaware of and wouldn't,
No,
but
I
it should be
understand.
subject to the act.
I just want you to know that we're talking about that now on the Senate floor, in case that's relevant.
Yeah.
So just whether or not their revenue, if, and when they are selling, is separate.
Right. And I would prefer that they not sell it in the first place rather than us get the revenue. Just,
Oh, yeah.
Right.
No, I was thinking what kind of medical information would be outside HIPAA? Right,
right,
that's all protected. But I suppose if I were buying abortion pills on the internet, that would be valuable
Right.
data to
So-
some states.
So for what that's worth, even outside the exemption, that sort of thing should be picked up by consumer health data, which is subject to
That's
even
what I was
additional
thinking.
controls under the act, but
Okay.
let me just,
Let's dive in because your time is precious this morning.
so we did the applicability section last time, I believe. If you guys want to go over that again, we can. That is where I started the overview of who's subject to the act, but the logical next place to go would be the exemptions, which is directly on point to the conversation that we're having.
Okay.
So this would
that's on
be
page
bottom of
16.
page 16, this is section 4417, starting on line 15.
okay, hold on, let's just, okay, say it again. Take your
It's up there.
It's also on the
Okay.
screen, but it's bottom of page 16,
Yeah,
Yeah.
starting on line 15.
got it, thank you.
So lots of close numbers, we also have 2417.
Yeah.
Chapter does not apply to, one, a federal, state, tribal, or local government entity in the ordinary course of its operation. So this is an entity level exemption. We start with to clarify that for government entities, they are not subject to this act.
So we can do what we want with our.
Well, we have to have other regulations.
No, but this is important for our policy work. We need to know some of this data and some of the, this data is in, yeah, okay.
Government has the absolute right to invade your privacy, but companies don't, that's what we're saying.
Yeah. Companies are people.
That's what we're saying.
Well, we're covered by
Yeah,
other
we are.
protections
Okay.
generally.
And just to
Lovely.
structure that particular piece, as we go through the exemptions, what they're meant to recognize is if there are existing independent privacy regimes in place that we don't want to duplicate, there may be some instances where it is a call out to a particular entity irrespective of those independent regimes, but the idea is to preserve as much as possible some coverage of privacy, whether through this act or another independent
And
regulation.
there are entities like banks and insurance companies that are.
We'll come to that.
Yeah, they're strictly regulated now. They
Yep.
have all kinds of. I don't know if the state has a privacy policy or what it is, so I think I would like to hear that if we're exempting
So
this.
they have
We
privacy
do.
bulletin and like, we can,
But I don't know that. I've been in this building for a lot of
Well,
years.
That's a great idea. We will, let's
Yeah.
review it when you,
and you may want DFR folks to,
yeah, I think that's part of why we're having DFR
Well, ADS, food needs.
and ADS. Oh, good idea.
so second exception, protected health information that a covered entity or business associate processes in accordance with, or documents that a covered entity or business associate creates for the purpose of complying with HIPAA. The technical terms you see here, PHI, covered entity, business associate, these are HIPAA terms. They're defined in the definition section to track HIPAA. So this is your recognizing HIPAA as an independent privacy regime and not duplicating the efforts there. Data level exception, process in parts with HIPAA. The set of exemptions you're going to see that 2 through 7 are all health related as well. 3, information used only for public health activities and purposes described in federal law. That's the disclosure of protected information without authorization. So again, HIPAA related. 4, information that identifies a consumer in connection with activities that are subject to the federal policy for the protection of human subjects and in various other federal regulations, and research on human subjects undertaken in accordance with good clinical practice guidelines issued by the International Council for Harmonization of Technical Requirements for Pharmaceuticals for Human Use. So this is testing on human subjects, information in conjunction with that, and it's calling out federal statutes and international guidelines here. And this is seen in other states as well. This is not something that we crafted for our purposes. Activities that are subject to the protections provided in the FDA Clinical Investigations Protection on Human Subjects and FDA Clinical Investigations Institutional Review Boards, or research conducted in accordance with those requirements or otherwise in accordance with applicable law. So this is a section that's related to human subjects testing. 5, patient identifying information that is collected and processed in accordance with this federal statute, which is confidentiality of substance use disorder patient records. I believe this is related to tracking pharmaceutical sales. Just a few piece.
Sense?
6, patient safety work product that is created for purposes of improving patient safety. Under federal law, patient safety organizations and patient safety work product. And 7th, information or documents created for the purposes of the Healthcare Quality Improvement Act, regulations adopted to implement that act. So 2 through 7 are your health data, data level exemptions. And 8,
Can I,
yes,
so.
Yeah. Wendy.
Thank you. So there's the health data that's collected in by official bodies that I have confidence is being. Hopefully I should have confidence in that.
You do.
But then there's health data that's kind of random, based on folks' searches, the kind of stuff that Senator Cummings was talking about.
Buy at the grocery store.
Right. So is that protected somewhere?
yes. So unless it is picked up by one of the exemptions, meaning that what you're referencing is protected health information that one of these specific entities, a covered entity or business associate under HIPAA, unless that information you're talking about is picked up by an exemption like that, that information should be protected. And the idea of it being picked up by the exemption is that it would be independently protected by HIPAA. So in either case, you're getting coverage.
Right, but my understanding of HIPAA is that it only applies to medical professionals and now these other
Exactly.
categories that I didn't know about. So if an employer might have health information on an employee.
Sure.
So that
that-
medical information, is that protected elsewhere in this bill?
So the employer, to the extent that they have an awareness of employee health information, is not part of that exemption because they wouldn't be a covered entity or business associate under HIPAA, and therefore they're not in that subdivision 2. So they would be subject to the act unless there's another bucket that picks them up, and we're going to be walking through
Okay.
all the buckets. But the idea is that those things, and to the extent that the things we're talking about are not picked up by the exemptions, meaning that it's not processed by that covered entity or business associate or done under some independent federal regime, you have consumer health data protections in place in a specific section that relates to what's done with that information, and it is subject to extra protections.
Okay, I think our chair had a question.
Yeah, maybe this is covered in the law enforcement piece, but there are more, I don't know if you'd say companies like Social Sentinel that have tried to use data to determine if somebody's becoming radicalized, purchasing guns, making a plan to cause harm to others. Did House Commerce look at that?
What did House Commerce?
Yeah, it feels like there's two pieces there. As far as there is like a whole section as far as not getting in the way of things like investigations, emergency situations, that kind of stuff. But that would be a great case to like look at specifically. We didn't like hear from that entity specifically.
Yeah,
Okay,
because
Magali, will you find an email for Social Sentinel? I think they sold out of Vermont, and if you have trouble, I'll try to contact the last Vermont founder.
that's a great idea. Okay. Is that, Keisha, is that it? You want to have something else?
That was it. Oh,
Okay,
I'll put my hand down.
Great, so now we move out of the healthcare exemptions and we're into, is this next group a group by subject or is it just?
I'll call out, so the last piece on this, we did 2 through 7, which are health pieces, and then we have kind of a bucket at 8, which is meant to be sort of a practical exemption to pick up information that originates from, or that is intermingled so as to be indistinguishable from, or that is treated in the same manner as information described in those subdivisions, that one of these specific institutions, covered entity, business associate, or qualified service organization program creates, collects, processes, uses, or maintains in the same manner as is required under those laws, regulations, and guidelines. So what this means is, if you are one of these specific entities that we've been talking about, and you have information that's coming from data that fits into the one of those buckets in 2 through 7, or that is intermingled so as to be indistinguishable from, meaning that they're maintaining
Right.
this data together, or if you're treating it in the same manner, meaning you're treating it under HIPAA regulations, you're treating it under those federal laws, you're applying the confidentiality and privacy protections that you need to apply from those independent regimes, regardless of whether or not it originates from or is intermingled. And you're one of those specific entities, that information will be exempted from the provision, from the protections of this act. And the idea there is that, again, that information is going to be protected. It's being protected under those regimes, so you're not losing protections by exempting aid, which is meant to capture that for a practical consideration that folks might maintain their data in ways where they can't distinguish between these. We have a similar bucket later on related to GLBA financial regulations. We next go to 9. So this is for your employers. So this is information processed or maintained solely in connection with and for the purposes of, and it is important to call out, it has to be in connection with and for this purpose, not simply that they collect the information, it has to be used for these purposes. Information enabling an individual's employment or application for employment, an individual's ownership of or function as a director or officer of a business entity, an individual's contractual relationship with a business entity, an individual's receipt of benefits from an employer, including benefits for the individual's dependents or beneficiaries, or notice of an emergency persons that an individual specifies. And again, these are all solely in connection with and for the purpose of enabling these purposes. So it's that purpose allows individual's employment or application for employment. If you applied to a job, they deemed you, or maybe they hired you, but they retained that information, and that they weren't using that information for purposes of your employment, but were instead trying to somehow sell your data, that would not be exempted. That would be subject to the protections of this act.
Right. But one assumes that employers hold information about their employees.
Right, and this is not meant to disrupt their ability
Right.
to do that. So to the extent that it is used for those purposes, it is exempt and they don't need to worry.
Got it?
Can any activity that involves collecting, maintaining, disclosing, selling, communicating, or using information for the purposes of evaluating consumers' creditworthiness, credit standing, credit capacity, character, general reputation, personal characteristics, or mode of living, if done strictly in accordance with the Fair Credit Reporting Act, and it has to be done by particular entities, a consumer reporting agency, a person who furnishes information to a consumer reporting agency under federal law, or a person who uses a consumer report as provided under federal law for principal purposes of the consumer report. So again, this is information about creditworthiness, but it has to be activities done in accordance with Fair Credit Reporting Act and by one of these entities, consumer reporting agency, furnisher, or a person using that under federal statute.
Great, and
I'm on the VSAC board, and since loan repayment scams are the newest thing, I think I've been fingerprinted 3 times. I've had credit records. They all have to go to other states, I guess, to prove that I'm not in a position where I might steal the state's money. I don't know if the state of Virginia that has my information is exempt from privacy. Is my consumer record information, I assume there's account numbers attached to that. Is that all not privacy?
I'm not sure I'm totally, is the question about,
The state, a state, but if
Oh,
it were
okay.
here, if Vermont were receiving information, I'm not sure what kind of
so
protection my information
Sure.
has.
So I think that, and I may be building some presumptions into my answer, I think that to the extent that the government is receiving that information and using it in its ordinary course, that government entity would be exempt. However, whoever they receive the information from, so if they're going through some particular entity, there would be a question as to whether there's applicability to that entity. If you're going directly through the state is taking your fingerprint for their particular
I
purposes.
am sending the fingerprints and my credit report to a state. I don't know which department in the state. It's the one that's regulating consumer fraud, I assume. They want to make sure that BSAC is an entity that is reliable and not defrauding students trying to pay off their loans. I don't know where that information rests, or could it be published as a, if, the credit worthiness of,
Right.
if they denied VSAC and we challenged it, could they present everybody's consumer record and say, see, we didn't think these people were reliable?
Right. So I think if it's a government entity, they're exempted under this in ordinary course, but I can't write this, but,
Okay,
but
I wanted, if,
You want to respond? And I think you have a response here from Monique.
I just want to clarify the government and the state piece. So, federal is exempt, and state with a capital S, which is very critical. It's one of those sticking points where that means Vermont. That is read as Vermont, not like
right,
Virginia.
I know.
Yeah,
But if that were coming to Vermont,
right.
if my information would be sent to the Agency of Human Services, what protection do I have that to know? I don't know why. I have problems with requiring everybody else but us to comply. And
You could change that, for when it's AHS, say, taking your data for uses of like the ordinary course of what they need to do to like process and do business operations, that's exempt currently. It is not if they were like selling that or something to Virginia or sharing that with Virginia. Virginia is not exempt.
okay, that's what I
so,
mean,
yeah.
my information has gone, if somebody's information is coming here.
It's,
When we got into this, I never thought, but could that department sell it on the QT to make up more
Unless
money?
they're sharing it with, like, say, I don't really know like all of the scope of the industries that would be taking your data, but if it's like AHS shares it with some rando Virginia organization that's not
Yeah,
otherwise
this is the,
exempted.
I believe the treasurer's office in Virginia, we had our treasurer's.
So they could be captured by another exemption. That's a great case to look into. I definitely suggest
Yeah,
it.
well, let's put a pin in it.
Yeah.
And let's put a pin in that question. And
so next, this is subdivision 11, your exemptions. This is information collected, processed, or disclosed under in accordance with a set of different laws and regulations. So this is data level exemption recognizing independent regimes. So Driver Privacy Protection Act, DPPA, FERPA, the Family Educational Rights and Privacy Act, the Airline Deregulation Act, the Farm Credit Act, and federal policy regulation of listed chemicals in certain machines. Maybe this is the pharmaceutical tracking piece. But again, this is data level exemption for that information that's collected, processed, sold, or disclosed under in accordance with these specific laws. So it has to be done in accordance with those laws.
Right.
To the extent that you start not abiding by the law, you're picked up by the act. That's the idea. Our 12th, we're jumping into our financial securities banking, this bucket. 12, non-public personal information that is processed by a financial institution, subject to the Gramm-Leach-Bliley Act and regulations adopted to implement that act. Non-public personal information is a defined term in this draft, but what it references is GFBA. So these are understood term, and financial institution is the same. The particular definition you see here for financial institution is not Vermont's definition for financial institution. This is tracking GFBA. So this is meant to be crafted specifically to get at what is regulated under GLBA. It's meant to be, I think it's sort of the narrowest achievable thing we could do on the House side.
and when was that act enacted?
So we talked about this last time. I looked it up, 99.
Yeah, I know, at least I'm consistent.
So I think we were between the two of us is what happened. So we just averaged the two of us, we get the right answer. Next, and here's that bucket again that I called out. 13, information that originates from or is intermingled so as to be indistinguishable from information described in subdivision 12 of this subsection, and that a controller or processor collects, processes, uses, or maintains in the same manner as is required under all the regulations specified in that subdivision 12 GLBA. 14, we're getting to entity level exemptions. A financial institution, and now we're talking about Vermont defined terms. So this financial institution, and this is made clear in the definition section, is referencing Vermont statute. Financial institution, credit union, independent trust company, broker dealer, or investment advisor, or one of those entities, affiliates, or subsidiaries that is only and directly engaged in financial activities as described in federal law. Entity level exemption for these folks. 15, a person regulated pursuant to Part 3 of Title 8, other than a person that alone or in combination with another person establishes and maintains a self-insurance program that does not otherwise engage in the business of entering into policies of insurance. To call out what this is, these are your insurance industries. There's a lot of captive insurance in there. So this is the idea that DFR has regulations in place.
Right. Which we
We
don't
did not want to duplicate, but you may want to hear on that particular piece, but this is entity level exemption for persons regulated pursuant to that.
They have one privacy policy. Because some of the changes we made this year were taking old things that had personal department privacy policies, and I know they now have office-wide, department-wide privacy policies.
Right.
16, this is another insurance entity, a third-party administrator, as that's defined in the third-party administrator rule, adopted pursuant to Vermont law, Title 8, Section 9417. The third-party administrator rule does set out particular obligations for those third-party administrators. I'm not in any way an expert on this, but this is part of that insurance entity level exemption bucket. We jump next to a separate set of exemptions, personal data of a victim or witness of child abuse, domestic violence, human trafficking, sexual assault, violent felony, or stalking that a victim services organization collects, processes, and maintains in the course of its operation. So this is that kind of data, which is obviously highly sensitive data, but it's only as those victim services organizations collect, process, or maintain it in the course of their operation. And
But mightn't some of that be public record? Sometimes when there's a court and a trial, eventually names get released, they're in the press. At what point is it that privacy? I know they try not to print names, but names frequently
right.
are released.
So this is specific just to the victim services organization, meaning that to the extent that it's disclosed outside of these contexts, it should be picked up and subject to the protections of the Act. 18, a nonprofit organization that is established to detect and prevent fraudulent acts in connection with insurance.
Yeah, nobody did those organizations. What are those organizations?
I've not heard.
Which one?
The nonprofit.
Nonprofits protecting and preventing.
Established to detect and prevent fraudulent acts in connection with insurance.
I think that we drew this language from Oregon.
Yeah, I would suggest the insurers.
I think we have a
Yeah,
bunch of
measures.
insurance whizzes in the room.
And I can give some context to the exemptions section if helpful when we're done.
Patrick,
And we're very close to being
Yeah.
done with the exemptions. So
Yes,
19,
they're already 19. It's
Thanks.
astonishing. This may be the most number of exemptions of any bill I've ever seen.
Was also one of the most comprehensive bills.
Yes.
non-commercial activity of a publisher, editor, reporter, or other person who is connected or employed by a newspaper, magazine, periodical, newsletter, pamphlet, report, or other publication in general circulation. The non-commercial activity of B, a radio or television station that holds a license issued by the FCC. C, a nonprofit organization that provides programming to radio and television networks, or D, an entity that provides an information service, including a press association or wire service. You can see the theme of these extensions being to get around some First Amendment concerns and allow news media to continue operating. I think that's the I have one more piece, it's included here, it's a little different, I'll go ahead and call it out and maybe it's worth turning over. So the subsection B, this is controllers, processors, and consumer health data controllers that comply with the verified with parental consent requirements of COPPA shall be deemed compliant with any obligation to obtain parental consent pursuant to this chapter, including pursuant to section 2420, which relates to minors. So this is just calling that throughout the draft, when you see requirements for consent, it's letting these folks know that if they're meeting verifiable parental consent requirements, which if they may be familiar with from COPPA, they will be deemed compliant with the requirements under this act. So this is kind of an assurance to those groups. Children's Online Privacy Protection Act. So that's our definition of kid, tracks that. It's under 13. You'll see multiple provisions built throughout that are meant to align with COPPA, which is
So it's children's, or say it slower.
we just scroll up to
Online.
make sure I'm calling this out.
It should be there. Could be children online.
Yes,
Yeah,
Children's
that's right.
Online
There it
Privacy
is.
Protection Act.
On page 4.
Well, we could have talked about.
We
that
talked about it with Kids Code.
With
I
kids.
just didn't remember it. The what is acronym stood for. Thanks. Okay. Any questions on the exemptions? You had something you wanted to
Yeah,
say.
just touching on a few questions that came up, and then maybe if I could just broadly do touch on exemptions. So, the non-profit insurance fraud piece, that was the National Insurance Crime Bureau. That specifically had a request for that so they could operate in insurance investigations.
I'm sorry, say again, national.
The
which
National
number?
Insurance
Which
Crime
number?
Bureau, for the nonprofits,
Oh,
18.
18?
Yeah.
The nonprofit
Yes, that's
organization.
right,
Is
I
that
didn't
okay?
know there was.
Well, apparently there's
Good
one.
to know.
And then Senator Cummings, for your question about like the court records and stuff, so publicly available information, this is back in the definitions piece, means information that's the first part of this, let's call out for you, is lawfully made available through federal, state, or local government records. So that would be like, that is calling out that there's a difference between something that's public, including government records, versus something that's like private and like, yeah.
To go to court.
Totally,
Get
yeah.
court records.
Exactly, yep. And then as far as exemptions overall, so this was largely, whereas most of the bill is taken from Connecticut, the exemptions piece was taken from, after conversations with other states, including Connecticut, was taken from Oregon as a state that like, this is actually seen also in the Connecticut AG's reports, which they did 6 months after kind of their law, establishing their law, which is their AG was like, you need to try to get as close as you can to completely using data level exemptions versus entity level exemptions.
Yes.
So whenever like a lobbyist or advocate or anybody had a conversation with me about like, we need an exemption, we don't want to be covered under this. The questions I asked, and I would recommend you like consider as you're taking testimony, and I can send these in writing just so you have the questions I sent to people, but was broadly like, what is the data that you are actually using or tracking for people? Why are you doing that? And
And what do you need it for?
what do you need it for? Yeah, what are you doing with it? And then lost my train of thought. When it comes to saying that like this statute is going to get in the way of whatever they're saying they need to do with the data, then what is the specific line or piece of the law that they're saying that's getting in the way of? And then how would they suggest changing that? And so in a lot of ways, it's like that was, if you were asking for exemption, we need you to specifically say, what is the data level exemption for the data that you're trying to collect and why you're doing it? And if there's a federal or state regulation that we should be taking into account, what is that? And then also I asked for like, what are other, if you're claiming other states have already done this for you, what are the specific call-outs that other states have given you so that we can build something around that? So just, we were really trying to focus and narrow this in on data level exemptions versus just blanketly saying like an entire sector or type of business is exempted.
Yeah, that's what you mean by entity.
Exactly,
It's-
yeah,
It's a business.
yeah.
Focus on the data, not the business.
Right, and so for an example, it's like when it came to working with Blue Cross Blue Shield, back in the room, and the health entities, HIPAA, yeah, is like we worked, I feel like trying to get a data level exemption, so in where HIPAA, where an entity is already doing HIPAA, like you had
Yeah.
mentioned earlier, if they have other data that falls outside of the realm of HIPAA protections, we have a data level in here that says if you have data that's not already covered by HIPAA, but you follow HIPAA, then you're agreeing that like you'll treat all of your data at the same levels of protections as HIPAA. If you don't, then you would fall under this act. But like generally, that's what we were getting at with trying to like do like a hybrid data level.
Oh, that's helpful.
Yeah, so there, I would say that the majority of the hundreds of hours that went into this bill, it was spent on exemptions and trying to like craft those and work with this industry to open us, so.
All your life.
Yeah.
So who isn't it?
And so there's, I would say, there's I was talking to Senator Hinsdale that there are some either pieces we were still trying to navigate at the very last, like before we passed this out, or entities that we had not had time to like testify. And I'm like preparing a list to give to all of you that's like, here's some things you might consider. One, and also in that saying like, here's things that we were pretty set on, but it was too late to incorporate. And here's some things that you want to take some testimony on if you want to consider them. And here's some other things that like we didn't want to consider, but you might want to. So I'm gonna share that. Exactly. Yeah.
We still may want to.
So I'm working on a document that most of the people on this room have pieces of that. So
Senator
yeah.
still has a question.
Oh, there she is. I had just checked and she hadn't had her.
This might be further down the road, but I'm curious, and I can hear probably directly from witnesses if some of them wanted a data level exemption because otherwise they would be subject to a private right of action. So if the exemption was a substitute for concerns they had been covered under a private right of action.
I would say more broadly is that they just don't want to have to comply with any of this document versus any one particular piece of it. Yeah.
Okay. John, let's keep moving.
Let's do it.
Yeah, you haven't been called to the floor yet, which is good.
No, I am getting requests to draft 4 amendments, which is gonna be hard to do, but guess I won't get them.
Or maybe
So-
not immediately.
Section 2418, this is jumping into the creation of those consumer personal data rights. So a consumer shall have the right to, 1, confirm whether or not a controller is processing the consumer's personal data and access the personal data unless the confirmation of access would require the controller to reveal a trade secret. 2, obtain from a controller a list of third parties other than individuals to which the controller is transferred at the controller's election, either the consumer's personal data or any personal data. So to explain this, the second clauses of this subdivision 2, this is meant to say that the consumer has a right to obtain a list of third parties to which that data has been transferred, but the controller gets to decide whether what they respond with is a list of the third parties to which the consumer's personal data has been transferred or any personal data, meaning all the personal data. So if they don't manage, if they just have a set of third parties that they distribute personal data to, but they aren't otherwise aware of or don't track what your specific personal data goes to, they can respond with, here's the set of third parties that we send personal data out to. So you get kind of an exhaustive list of the third parties that your data would go to, and therefore you have notice as to who you would need to reach out to if you're concerned about a particular problem. That's the idea. Of course, them the flexibility to not disrupt how they might maintain their.
So sometimes, at some point, as we go through this, I'm realizing I may need some good concrete examples.
Right, well, there's
Not immediately, but
there's things you
that
can put on
illustrate it.
your phone or computer where it shows you all of the tracking entities and you'll see there's like 5 of them and then
Oh, you'll have to
you
show
go
us
somewhere else and then there's 10 more and they grow like bacteria. I mean, there's
So I'd love
lots.
to you show me how to that on my
Yeah.
phone. Or
Yeah,
the
it's
whiz over here.
really alarming and we
Well,
should share that.
Sure, it's alarming that parents are able to track their children. I find that very alarming. But anyway, here we are, tracking
Well,
some
well,
particles.
Filled,
Keisha has a question.
Yeah, the parental thing is a whole different
Yeah,
conversation.
I know.
Yeah.
Keisha. Are you there?
No, sorry, my hand was just still up. I'm putting it down now.
Oh, okay. John, let's keep going. Oh, you need to turn.
No, I'm just trying to tell people that I'm in here, that's. So trying to protect this.
We like.
Oh, they're not tracking you,
You know, we're.
not effectively.
They already-
I was gonna say, it's an ID badge, yeah.
I try to be live streamed at all times.
So John, in your court here,
Consumer has the right to third, correct inaccuracy in the consumer's personal data, taking into account the nature of that personal data and the purposes of the processing of the consumer's personal data. Fourth, delete personal data provided by or obtained about the consumer. Fifth, obtain a copy of that personal data processed by the controller in a portable and to the extent technically feasible, readily usable format that allows the consumer to transmit the data to another controller without hindrance, where the processing is carried out by automated means, provided such controller shall not be required to reveal any trade secrets. So you'll see that call out the trade secret in a couple places just to ensure that their controllers aren't having to disclose sensitive pieces of their own information.
so this is if an individual wanted to transfer their stuff to another company.
Exactly.
It's pretty interesting to see what they have for you. It's almost like looking at your credit score. It's actually looking at more data than is in your credit score.
It may be too frightening.
Exactly,
And
but it's reality, so the consumer should have that.
another piece of this, and I don't think I didn't speak about this, but at times when you are having data processed, say for credit or certain applications, you're submitting an application fee to do those things. So if you can obtain a copy of that personal data in a portable format, theoretically, maybe you can not have to duplicate certain fees in certain instances.
That would be great.
Not something I thought of until just now, but maybe that's in part what this facilitates.
Is that? Do you
They'll still
want to do anything?
No, I'm just gonna note that.
Seems consumer friendly from my
Yeah.
perspective.
Yeah.
And they're right, so obviously they don't have to exercise it to the extent they don't want to. And sixth, this is a big one, and I should call out that this sixth right is treated a little bit differently than the others throughout, and I'll call out when it's the case. Sixth right is to opt out of the processing of personal data for purposes of targeted advertising, sale of personal data, or profiling in furtherance of solely automated decisions that produce legal or similarly significant effects concerning the consumer, which we talked about that concept earlier. So these three sets of categories: targeted advertising, sale of personal data, profiling for those significant decisions. Consumer has the right to opt out of the processing of personal data for those purposes.
So a question I'm gonna have on this is there a universal opt-out so that you don't have to opt out of every one of those individual
So when we get
entities?
when we get to the data broker section, there is a universal opt-out piece. There is no universal opt-out for this. I mean, we could have. It may be a rabbit hole to go down to.
Well, you can do it by phone, because there is the identifier of the phone, so we'll just talk about
So
that if it's not very in.
Let's put a pin in that, because, I mean, just think of how sometimes incredibly impossible it is just to unsubscribe from this
Yeah.
junk email.
Yeah, so
And it's just unbelievable
those
how
sorts.
difficult some of them are. It's not always easy to unsubscribe.
I get on my state house, 3, 4, 5, 6, sometimes twice a day, things from politicians running somewhere in this country. I
Right.
don't know where they got. Or they just send them to all of us.
Yes,
It's
they send them
annoying
to
to
all.
sit there and
Yeah.
wipe them all
I know
out.
it's a pain and they aren't always easy to unsubscribe.
No, I've tried to unsubscribe to many things and I have yet to succeed.
I know.
So the data broker piece will deal with this to the
Yeah.
extent that you're talking about entities that don't have direct consumer relationships with the consumers, that's a data broker. And there will be a universal opt-out provision through the Secretary of State, or at least that's what's proposed in the bill, so that you can check
Cool.
that and get out of those sorts of things, whether that would be effective, is another
Right.
question.
But I think.
Yeah.
We gotta try.
But in this section, it would be great to be able to have a universal.
I just wanna like raise the philosophical over kind of arching theme here for talking about opt-in and opt-out versus data minimization pieces of like if an entity is actually adhering to the minimization processes of like expectations of they're only collecting the data and you like that they're collecting and they're using it for what they say they are and all that kind of stuff, then like the opt-out is the more strict you kind of tends to make that, the more like irrelevant the opt-out opt-in becomes because they really should only be using the data that you realize they're using for the purposes yeah. Anyway,
Yeah,
it's an overarching.
no, that would
theme,
be,
and the
these
wonderful if we could trust them to do that.
But then the interesting balance is that, of course, consumers want information when they want it. So if there is less data collected, you may not have this great information going to Google Maps or to something you want.
Exactly.
And so
But
it's,
that should be your
it's an
choice.
interesting balance
Totally, yeah,
between
absolutely.
data
Yeah.
that everybody wants when they want it and data that, anyway,
Yeah.
it's
Just a question on the
Yeah, Brandon.
applicability, many of the restrictions that we're talking about. I can see things that apply when you're within the state and an activity you provide within the state. What if you're a data broker or someone else who's outside of Vermont, who picks up data about you on the internet,
Where
which
you're
they
traveling.
obtain from where they are located? How does this apply to them?
So I probably would want to double check this just because I recall less of the data broker piece, and I can jump down to that if you want to do
Well, I'm
that.
not
just so we
talking
can
about, I'm not
cover
talking
this.
about
Let's when we
anybody
get
who
to it,
gathers
let's-
data, whether they're a broker or not. But if they're gathering data from you, they're sitting in Omaha doing it on the internet, and the information is available to them at that location on the internet. The fact that you live in Vermont, the question is, does the reach of this bill in any way apply to them at all?
Right, so for outside of the data broker subchapter, when we're just talking about the Vermont Data Privacy Act, it can apply to the extent that those folks are targeting. So the data broker is a little different, they're not having a direct consumer relationship, so we really are talking about that specific subchapter. I'm starting to go
Not necessarily
into.
data broker, but any individual who just wants to know about you. And they're sitting outside of the state, and the information they are gathered, or that they receive, is received by them outside the state. How does this apply to them?
So let me. Sure, now,
Do you wanna?
I think that's where the definition of consumer comes into play, right? That it is this covering residents of
it
Vermont.
does cover residents, but if the
Yeah.
question is related to businesses outside of the thing I want to make sure I get right is, I think that there may be, and we'll get to it, data brokers, so the entities outside of the state that don't have the direct relationship with you. I think there may be a commercial aspect to the definition, that it's not just random person sitting in a room, that it's someone is carrying out these, is collecting this data for a purpose. If someone is just picking up information but not doing anything with it, that's not a data broker. They need to be selling, doing something with that data. But to the extent that they're outside of the state and they are selling that information, they are picked up and would be subject to the data broker subchapter, meaning they would need to comply with the
In
opt-out
other words, if
provisions.
they are outside of the state and they're selling data that relates to a Vermont resident, but all of the material that they got was obtained outside of the state, you're saying that this is going to drag them into a violation of Vermont law?
Let me jump to that just because I do not want to.
Because I don't wanna, if it's premature, I don't wanna have us go down as we're going through this. We could also discuss this when we get to it.
Oh,
And,
we lost a court case on data mining.
yes,
The pharmaceutical
Very true.
companies get prescription records. No names attached, but they get prescription records from the pharmacy. I'm not sure if there's some money that changes hands further up the line, but it isn't to the pharmacies. And those go to the pharmaceutical companies, which then start with, how come you're not, the doctors, how come we're not selling our new pink pill, you're still prescribing our old green pill? And we lost that in court. This goes with, this isn't personal data, it's no names attached. But can you sell that? We're looking at, came up yesterday, personal data. Oh, can Comcast give the E911 board my phone number and address, but not my name without my permission?
So I'll
This,
try to answer that. I did want to not forget Senator Brock's question. So I don't know if we're jumping to, I want to make sure we're either definitively not resolving that question today and coming to it when we get to that subchapter.
I think
Yeah,
he's
that's a big
articulated
question.
that
We
big
need to-
question, and I think
it
That's
is.
a pretty important question.
Yeah, it is
Yeah.
critical.
So
So,
do we want to jump to that today, or do we want, because what we're talking about today is, there's two separate pieces of this bill. There's Vermont Data Privacy Act, and there's tweaks to the data broker
so
section, which is what
I
we're-
think I'd love to get, when we get to broker act, let's articulate and keep Randy's questions, it's important. But let's finish our walkthrough here, because
Just understand, when we do come to it, I'm not only asking a question about data brokers, I'm asking about anybody
right, you're talking about outside.
outside the
Outside
state of
Vermont.
Vermont. That's the information of Vermonters, details some of the things we're talking about, whether consumer data
Right.
or otherwise. But they are located physically outside the state, and their access to the information occurs outside the state, such as on the internet. And I'm talking.
Oh, okay, okay.
Yeah, and I'm not just talking.
Okay,
about
so
that.
someone who is outside of the state who is collecting, they're collecting the information of Vermonters, the business is just not situated in Vermont.
Right.
They are subject to this act, yes. Yes,
So someone is, I just wonder about being subject to the act, is there a First Amendment issue? Is there a federal issue involved, by taking our law about someone who is sitting someplace else, getting information someplace else, just because it's Vermonters, is subject to this act?
so to me, this would be a question of dormant commerce clause is the way that I would think about this, like, is there some extraterritoriality implication to this? Are we regulating conduct outside of the state? If you want a deep dive on that, I would want to come with good research on it. I will say that crafting the definition of consumer, which Representative Priestley was referencing, was done, we went through a couple of iterations. And one of the iterations was that it would apply broadly to visitors to the state passing through or any, essentially. And there were concerns that there would be extraterritorial implications for doing that. So the draft backed away from that and limited the definition of consumer to address this dormant commerce clause issue and just apply to protecting Vermonters. The nexus for saying that we're not regulating extraterritorial conduct is that we're talking specifically about activities that are affecting Vermonters here. So the business may be outside of the state, but what they're doing is affecting the Vermonter here. So that's the idea. But if you want kind of like a deep dive of constitutional analysis on dormant commerce clause, I would want to come with something just to have.
Okay,
Okay, we'll
That's-
come
that's
back to
good.
that, and just, I'll put that as an aside.
if you
And-
want,
But I
Yeah.
think it's an important issue, because I'm just concerned that we are overreaching if we move to that extent. I can see dealing with something that happens to a Vermonter that has a specific impact on that Vermonter, doing business with the business gathering information to sell about him or her, or an action that may occur in Vermont that would affect that consumer. But someone who is just interested in finding out about, people who fit a certain profile, wherever they may be, how you can force anything like that, and also how you would extend what they are doing, which is entirely outside of the state, with no touch to the consumer at all, other than looking at records that are available nationally or worldwide on the internet.
sort of
So-
aggregated
So
data.
okay, so there's a couple of things to say on this piece then.
Oh, Keisha's got a question too.
Should I go?
No, just finish with
Okay,
Brandy, and then
so-
Monique has something she needs to add to Brandy's thing, and then we'll go to Keisha.
A couple of pieces, to the extent that we're talking about publicly available data. That is not personal data and is not regulated under this act. So if we're just talking about publicly available information, you don't need to worry about that being picked up here. No one's gonna be subject to enforcement on that, under that action. Unless I was saying, it's
Well,
like
publicly available or privately available.
So-
What's public, if, there's that fine line.
Well, we have a, and I can scroll out, so we have a particular definition of publicly available information. And this is. Sorry. Subdivision 43, top of page 11. Information that A is lawfully made available through federal, state, or local government records, or B, the controller has a reasonable basis to believe that the consumer has lawfully made available to the general public through widely distributed media. So this would put under that B, which is, I'm guessing, more of the category that you're talking about theoretically being accidentally implicated. B is more of the category. This puts it on the controller to determine if they have that reasonable. Obviously, if someone brings an action under this, they're going to have to adjudicate this particular piece. But the controller just needs to have a reasonable basis. They don't have to have a firm basis. They have to have a reasonable basis, some reasons to believe that the consumer has lawfully made it available through widely distributed media. So there is a defined term for what this PAI is. If you wanted to build this out more, there's some competing things that people do, but this is a relatively standard and broad definition of publicly available information. There was one other. Yes, so to the point about just having records and it not affecting Vermonters. If what we're talking about is people just having, like they've received information, they're not collecting and they're not doing something, there's nothing for them to be subject to. Like if nothing is happening with the information, there's no basis on.
Well, for example, a company that maybe gathered information to use to measure purchase or sale behavior of people of a certain age. And it's not necessarily geographically related. I can see companies that are in the business of doing that, and that's just one of many examples. And I'm just wondering how far this law is intended to reach. That's really what I'm trying to get at.
Okay, and that's, I think you're gonna come back to us with
Sure.
more data, for more info on that, and Monique has a response to Randy, and then we're gonna go to Keisha's question.
Yeah, I would just, I guess two pieces here. I would align this to what you all just worked on with Kids Code. Like you're broadly looking at the big tech companies, the big social media companies, none of which are in Vermont, but are using data of consumers in the state of Vermont. So you're trying to protect.
You're trying to protect those people
Yeah.
in Vermont from a particular harm
Sure.
based on the data that is being held
Same
by
thing here.
and manipulated by.
Yeah,
And I'm not, the outside the state voyeur who is on probably the best case, collecting broad national data about behavior. It's hard for me to envision that they're doing something that is specifically harmful or dangerous to Vermonters and Vermonters' individual privacy. But they are using Vermonters' quote private information that they may get from a variety of sources that may be national in nature, such as the internet.
sure. Yeah. So I think broadly, like if we're talking about the things like, again, like social media companies or things that could do harm, that's what we're trying to capture. If it's like de-identified survey data and things like that, that falls under a kind of a different realm here, which John can like.
And data is also not.
So, like,
the
for
definition of personal
surveying
data
and
is
stuff like
not
that,
subject to the act, so.
And then, maybe just one more piece, when it like every single one of these, so at this point, there's been 15 now that have passed. Every single state is trying to protect its consumers. And so this broadly is right in line with all of the other states that like, they're trying to protect your harms from your people with the ways that people are making money off of and sharing people's data. So consumer protection.
Okay.
Yeah.
So on that, I think we're gonna pivot to Keisha's question.
Well, I
Okay.
raised my hand a little while ago just to say that the Attorney General's office, I understand, is in the room taking notes.
Yeah, Sarah's with.
Yes, so that they can come back to us with answers to some of these questions. As I understand it, also as a question, our Kids Code bill really made pains to go after the largest companies in Silicon Valley and worked with local Vermont businesses to make sure they weren't captured. We're going to hear from the Tech Alliance about that, but I will say I think Senator Brock's line of questioning is completely in order because these could be very small entities.
Right,
That could do a lot of damage, just one of the.
right, small entities, big impact.
Yeah.
Small
Those are the ones
entities, big
Yeah.
impact.
who are doing something for legal purposes. Lawful purposes as opposed to those who may not be,
Hmm,
which is a risk.
yeah. Okay, let's keep going.
Let's go on. Subdivision B1. So we've just gone through the set of consumer rights, just to return to where we are. We've gone through the 6 consumer rights pursuant section 2418. And we are on page 23, line 6. A consumer may exercise rights under this section by submitting a request to a controller using the method that the controller specifies in the privacy notice under section 2419. So we'll come to that. There's a set of information that has to be disclosed in that privacy notice. But they can exercise their rights under this section using a method specified in the privacy notice. Subdivision 2, a controller shall not require a consumer to create an account for the purpose described in subdivision 1. The controller may require the consumer to use an account the consumer previously created. This is meant to stop people from introducing obstacles to the exercise of those consumer rights. 3, a parent or legal guardian may exercise rights under this section on behalf of the parent's child or on behalf of the child for whom the guardian has legal responsibility. Again, child is under 13. That's aligning with COPPA, the Children's Online Privacy Protection Act. A guardian or conservator may exercise the rights under this section on behalf of a consumer that is subject to a guardianship, conservatorship, or other protective arrangement. A consumer may designate another person to act on the consumer's behalf as the consumer's authorized agent for the purpose of exercising those rights under subdivisions A4 or A6. So to call out those rights, that's deletion and your opt-out. So those are considered kind of the more regularly used pieces. So permitting an agent to act on their behalf.
That would be a good business, actually.
Yes, to go through.
Yeah, to say, I will scrub you.
You know what? You're actually right.
Yeah.
I would
I
have that person to help me do that.
You mentioned, back for a second, on the age of 13, is there a federal, in effect, definition that gets you to that age?
COPPA.
So COPPA is the one, yeah, so our definition of child, I think what we actually say is tracks COPPA. So if COPPA was amended, it would pick up whatever the changes are. It's meant to move in tandem with what's happening there. Gonna guess that under 13 is pretty stable there. A consumer, sorry, we just talked about 4A, that's
4A.
designating an agent. We're now at page.
I like, yes, I think that is one of the many businesses we could be promoting.
The consumer may designate an authorized agent by means of an internet link, browser setting, extension, global device setting, or other technology that enables the consumer to exercise the consumer's rights under those subdivisions. So this is meant to ease. We've talked a little bit about trying to make these pieces accessible and usable. Subsection C, except as otherwise provided, a controller shall comply with the request by a consumer to exercise the consumer rights authorized pursuant to this chapter as follows. So this is what a controller needs to do in responding to those requests. Respond without undue delay, but no later than 45 days after receipt. However, the controller may extend that response period by an additional 45 days when reasonably necessary, considering the complexity and number of the consumer's requests, provided the controller informs the consumer of the extension within that response period and of the reason for the extension. So if they're going to extend by 45 days, they can't just go the full 90 and then let the consumer know. They have to notify them within that first period that they are delaying and for what reason. If the controller declines to take action regarding the consumer's request, the controller shall inform the consumer without undue delay, again, but not later than 45 days after receipt, of the justification for declining and instructions for how to appeal the decision. Information provided in response to a consumer request shall be provided by a controller free of charge once per consumer during the 12-month period. So this is meant to be a cheap process, but it's also not meant to permit consumers to just bog businesses down with requests and not have to incur any costs on that basis. And you see that in this subdivision B on page 25, if requests from a consumer are manifestly unfounded, excessive, or repetitive, the controller may charge the consumer a reasonable fee for the administrative costs of complying with the request or decline to act on the request. However, the controller bears the burden of demonstrating the manifestly unfounded, excessive, or repetitive nature of the request. If a controller is unable to authenticate a request to exercise any of the rights afforded under A1 through 5, so that's your non-opt-out rights, that's confirmation and access, notice of third parties, correction, deletion, data portability. If the controller is unable to authenticate the request to exercise those rights using commercially reasonable efforts, the controller shall not be required to comply with the request to initiate action pursuant to this section, shall provide notice that they're unable to authenticate until the consumer provides additional information reasonably necessary to authenticate that request. So this is meant to say, if they can't tell that the consumer is who they claim to be doing, they don't need to comply with the request. However, if they're electing not to comply, they do have to reach out and say, we need this additional information. And so they're meant to try to achieve authentication in this section. A controller shall not be required to authenticate an opt-out request, but a controller may deny an opt-out request if the controller has a good faith, reasonable, and documented belief that the request is fraudulent. This is in recognition given the heightened importance of this opt-out right. And we probably don't imagine that there's lots of fraudulent opt-out requests, but they wouldn't happen. And just to call out, this is something that will come up later. If you opt out of particular kinds of processing and say that a company has a loyalty program in place, something to that effect. So you're, as a consumer, making a commercial decision that you actually want them to have your particular information. Someone has exercise fraudulently your right to opt out of processing, that business will have the opportunity to send you notice saying, do you really want to opt out? You're participating in this loyalty program. Do you want to remain in this or would you prefer to opt out? So in some instances, if there happened to be a fraudulent opt-out request, there would still be a practical mechanism for you to be notified that that's the case. But I think largely what the act was doing was recognizing that the consumer protective measure, so fraudulent attempts to opt you out of data, are not to the consumer's disadvantage. Unclear to whose advantage that would be. C, if a controller denies an opt-out request because the controller believes the request is fraudulent, the controller shall send a notice to the person who made the request disclosing that the controller believes the request is fraudulent, why the controller believes the request is fraudulent, and the controller shall not comply with the request. So again, in all instances in which you're not having your rights complied with by the controller, you're going to get notice that that is happening. A controller that has obtained personal data about a consumer from a source other than the consumer shall be deemed in compliance with the consumer's request to delete the data by A, retaining a record of the deletion request and the minimal data necessary for the purpose of ensuring it remains deleted and not using that retained data for any other purpose. So that's, you might want to know that you've had the previous deletion request. Otherwise, if you're continually receiving information, people are going to have to continually submit deletion requests. So you can retain a record of that deletion request, which would conceivably be a kind of personal data that you would otherwise be required to delete.
That's like our unsubscribe nightmare. Just keep filling them.
Yeah.
Even after you filled them, you don't want them.
So you can retain that and minimum data necessary for purposes of ensuring it remains deleted, or you can opt them out of the processing of personal data for any purpose except those exempted for some versions of this chapter. So that's exempted as in the exclusions that we talked about at the beginning. Basically, if it's not going to be processed for any of the reasons that this act is concerned about, we're not getting at something that the act is meant to protect, at least as currently explained. So those are two ways that the controller can comply with those deletion requests. Either A, essentially that's deletion, or B, opting them out of all processing except for exception.
So if there were enforcement, that would be how they would prove to the enforcement body that they had complied.
Yeah, exactly. They could show that the only, only information that we've had is we've retained this deletion request for minimal data necessary. Or they could say, yeah, we do have the information, but we're not processing in any of these ways. So
They would actually show it to the entity,
I mean, they would need to prove.
share it to
themselves.
the entity.
Yeah.
Alright. Okay.
6, a controller may not condition the exercise of a right under this section through A, the use of any false, fictitious, fraudulent, or materially misleading statement or representation, or B, the employment of any dark pattern. You'll recall from discussions of definitions last time, these dark patterns are manipulative design mechanisms to secure consent. It picks up any FTC defined dark pattern. So can't.
Yeah, I can see a whole cabaret act on the definitions in this bill.
Yeah.
Oh, there will be one. Script is already written.
Oh, God. I'll be sure not to.
Sorry, I
Right.
just, dark pattern is just like, whoa, there's a costume for that too. Okay,
Section D, bottom of page 26, a controller shall establish a process by means of which a consumer may appeal the controller's refusal to take action on one of those requests. So we've had all the pieces about receiving notice, they're not complying with the request. What can they then do once they receive that notice? They can appeal. The controller's process must, 1, allow a reasonable period of time after the consumer receives the controller's refusal within which to appeal, so a reasonable period of time to respond. Be conspicuously available to the consumer, and be similar to the manner in which the consumer must submit a request, so they can't design very different mechanisms for submission, but then hide your appeal under something very different. Require the controller to approve or deny the appeal within 45 days after the date of receipt, and to notify the consumer in writing of the controller's decision and reasons for the decision. If the controller denies that appeal, the notice must provide or specify information that enables the consumer to contact the Attorney General to submit a complaint. So even if we get to the end of this, consumers receive notice that the controller's not going to comply with requests. They've then gone through the appeals process. The appeals process was done in the proper way. Even at the end of this, they would then receive information that they could go seek enforcement action if they think that that's what's appropriate. Submit a complaint to the AG's office.
right.
So that's your consumer rights section.
That's all. It's awesome.
Section 2419, this is your duties of controller, so this is setting out additional obligations that the controller will need to comply with.
You have a roll call, you may want to go up on it. But no M and M's.
They doing budget? I thought they were starting budget. I think they're starting with budget today, yes,
I thought they did that yesterday,
they did, but
I mean, third reading
I think so.
and amendments. Anyway,
I just
I'll jump in.
yeah, go for it. Sorry, I just.
No, you're good, totally. Subsection A, so this is setting out what the controller shall do, we'll come to what the controller shall not do next. The controller shall specify in the privacy notice, the express purposes for which the controller is collecting and processing personal data. To process personal data only, and this is your data minimization piece, only
Right.
as reasonably necessary and proportionate to provide the services for which the personal data is collected, consistent with reasonable expectations of the consumer, this personal data is being processed. Or for another disclosed purpose that is compatible with the context of the personal data is collected. So they disclose a set of purposes, they're collecting for, certain services that they're providing, but they can process for another disclosed purpose if it's compatible with those services they're providing, essentially. There's nothing disruptive of what they were otherwise proceeding to do it. Or if they want to go beyond those purposes, they need to have a disclosed purpose and obtain consumers' consent. So they can go outside of what's kind of initial purposes, but if they try to do that, they need to obtain the consumer's consent. So you should know in that privacy notice everything, all the kinds of processing that you need to be concerned about. And if the controller wants to go beyond that, there will be a
There's a big
mechanism.
flashing red something that says, beyond this point, you need to say yes or no.
Yeah, we need to hear from controllers.
And to jump to something that will come later on, we'll have in session law in the bills, this does pass, education and outreach,
Yeah.
both to businesses and to consumers. So for businesses, trying to get them up to speed on what kind of mechanisms you would need to have in place, education they need to know on how they exercise their rights, how they work in conjunction with particular enforcement. And setting up like the privacy notices, if there's meant to be a template and, it directs the entities that will be carrying out the study, AG, I think it's maybe ACCD as well, to look to what other states that have passed similar regimes are doing.
Yeah, because it would be helpful for everybody to have a kind of uniform look to what the moment, a uniform look to these choices that we have to make. So that unlike these unsubscribed things, which are like completely
Right.
random, I mean, all of them are different. It would be really helpful to have a uniform look to the opt-ins, opt-outs, yes, no's, anything that requires a decision.
And one thing we haven't talked about today, but we may have talked about on day one, is the concern for uniformity, which isn't fully achievable, but to the extent it can be achieved across states with regard to the law itself as well. So there is some
Yes.
intent to align with language in other states intentionally. And so, for instance, I have received language from other states and been told to include it, and I'll say, I don't like the way that this is drafted. What we may end up using pieces basically is conceding to the fact that industries are accustomed to particular language and they want to see recognizable terms. That said, we do try to craft for readability and the like, but there is some effort in instances, and when Priestley is in the room, we'll be able to speak in certain instances where language has been included at request basically to call out terms that people are looking for. And so there is a broad uniformity request as well in the absence of federal legislation on this subject.
Right.
Which, as we all know, is what.
And this is one of the reasons we want to align our definitions, not just with the work we've done already with Kids Cup, but with this other states, so that there's uniformity. in a
Right,
lot of
to the
that.
extent that there's, certainly, it is
Yeah.
helpful to have that,
Yeah. 50 different.
Yeah, I mean, it's
codes,
still not
that's
gonna
gonna
work.
be very difficult.
it's also the reason that you have the long list of exemptions that you
Right.
do, is that people are accustomed to operating under independent regimes. And so long as they can maintain those and we feel that they're adequately protected outside of the scope of this act, should be good and maintain uniformity there as well, not have to create whole new processes are unnecessary. 3, controller shall establish, implement, and maintain reasonable administrative, technical, and physical data security practices to protect the confidentiality, integrity, and accessibility of personal data, appropriate to the volume and nature of the personal data at issue. And 4, the controller shall provide an effective mechanism for consumers to revoke consent that is at least as easy as the mechanism by which consumers provided their consent. And upon revocation, cease to process that data as soon as practicable, but not later than 18 days after receipt of the request. So again, trying to include provisions to ensure that controllers can't set up the initial mechanisms in an easy way for consenting and then have much more difficult processes for revocation, exercising rights and the like. So trying to tie those together. B, what shall the controller not do? The controller shall not want to process personal data beyond what is reasonably necessary and proportionate to the processing purposes. So this ties to your data utilization piece that, and I will scroll up. So they won't process beyond what is reasonably necessary and proportionate to the processing purpose. Let me scroll back up to A2. You'll recall that the controller has to process only as reasonably necessary and proportionate to provide the services for which that data is collected. And then we have these other disclosed purposes. What this language you see at B1 does is we say it shall not process personal data beyond what is reasonably necessary and proportionate to the processing purpose. That picks up the B and C that you see here at the top of page 28 for those other disclosed purposes.
Right.
But even beyond that initial disclosed purpose that is reasonably proportionate to the services for which it's provided, even when they're going beyond it, the controller is still obligated for those other purposes to process only as what is reasonably necessary and proportionate to that purpose. So this does add content beyond what is in A2. It picks up the B, C pieces. The controller shall not process sensitive data about a consumer without first obtaining the consumer's consent, or if the controller knows the consumer is a child without processing the sensitive data in accordance with COPPA. So required consent for that sensitive data category, which is large, you'll recall, picks up a lot of different kinds of data, including financial information. 3A, controller shall not, except as provided below, process a consumer's personal data in a manner that discriminates against individuals or otherwise makes unavailable the equal enjoyment of goods or services on the basis of the individual's actual or perceived race, color, sex, sexual orientation, or gender identity, physical and mental disability, religion, ancestry, or national origin. This doesn't apply to, and this is a call out to federal law, which is a carve out from federal discrimination law. So this is why this particular piece is called out. Shall not apply to a private establishment, as that term is used in federal law. Processing for the purposes of a controller's and processor's self-testing to prevent or mitigate unlawful discrimination. So this is meant to say, if what you're actually doing for your processing purposes is not to achieve discrimination, but in fact to mitigate unlawful discrimination, essentially that you're conducting testing, that is not picked up by the prohibition, or processing for the purpose of diversifying an applicant participant or a consumer pool. I will call out about this section. This is a more substantive anti-discrimination piece than we have seen in other states. The initial draft of this just had language to say, a controller shall not violate state or federal anti-discrimination law, which is of course already an independent requirement. What you would do by having that kind of language is saying, well, to the extent that it does violate those laws, it's now picked up as a violation of the Internet Data Privacy Act. This is a more substantive conception of anti-discrimination. But I will call out that this is not something that I can recall seeing in other states and want to speak up a little bit.
So not even Oregon? We're even ahead of Oregon on anti-discrimination things,
On this piece, yeah, yes.
right?
Subsection 4, the controller shall not process a consumer's personal data for the purposes of targeted advertising, of profiling the consumer in furtherance of decisions that produce legal or similarly significant effects concerning the consumer, or of selling the consumer's personal data without the consumer's consent, if the controller has actual knowledge that, or willfully disregards whether the consumer is at least 13 years of age and not older than 16 years of age.
So, question here, please.
Yeah,
So, say a person didn't opt out and they didn't do anything. A consumer was just using a particular system and had already provided data. Does paragraph 4 mean that the company can't sell their data for advertising, even if they don't ask that it not be sold for advertising?
For this particular age group, that is correct. So for under 13, processing of sensitive data,
Oh, that's only for that
children, so
age
children's
group.
data
Okay.
is sensitive data, and the processing of sensitive data requires consent. So that will already be picked up. What you're seeing here is for 13 through 16. Controller shall not process that data for these specific purposes, targeted ads, profiling for those significant decisions, or sale without their consent. But the controller
If
doesn't
they're
have a,
13
there's a
or,
mental state here, the controller has actual knowledge that, or willfully disregard
okay,
whether the consumer is in that age group. So for that age group, that's correct. Even if they have not opted out,
They have to consent.
they consented
it'd
for
be
part
great
for
if
that.
that could be for everybody. You know, and you
I'll
had to
look into
opt
that, yeah.
in for, okay.
Also, I will say, I do think this is what Rep. Priestley was trying to get at, is that this is an opt-out regime. This is not while it is a large bill that's going to accomplish a lot of helpful things for Vermonters and will have impacts, it is not meant to have such a dramatic impact as creating a wholly new opt-in regime for everything, which disrupts the flow of business. So that's definitely a deliberate attempt to have a structure that is opt-out. The whole bill is structured in this way, and to the extent that you see something that is not that, it is called out as sort of a special protection.
Okay,
And if you move in that direction, I will just say there's nothing wrong philosophically, it's not my call, obviously, and what you do on that front, but that is not the philosophical concept animating the bill, which is built on, the entire bill is built on this opt-out regime, and
Okay.
not being.
Yeah,
just
I
One
understand,
of the
but
foundational
this is,
Yes,
but this is language that could, this is the language.
if you were trying to craft this, then yes.
Yes.
And this is where a data privacy consultant that you could hire to help, and then the whole family opt in and opt out.
Right.
All right.
Okay.
Jennifer's job. If you can become a whiz at this, manage this, all this. Oh, yeah. That's something you could do right now.
Okay.
Okay, John, we have, ideally, I'd love to go. John, give me a notion of what you want to get through, because I'd love to give this committee a break, if we could.
Let's get through the rest of this section then.
Okay, let's finish this section, then let's give ourselves a break until we, meet with our new police chief.
And can I ask, Monique, what were they doing next on the floor? Do you?
Oh, I don't know.
Okay.
Sorry.
That's fine.
You just voted, so what was the vote of?
It was Donahue amendment.
At Donahue amendment?
Yeah.
Subsection 5, we are at
Right.
the bottom of page 29, we're talking about what controllers shall not do. The controller shall not discriminate or retaliate against a consumer who exercises a right provided to the consumer under this chapter or refuses to consent to collect or process personal data for a separate purpose or service, including by denying goods or services, charging different prices or rates, or providing a different level of quality or selection of goods or services to the consumer. So this is to say, you can imagine a controller might see certain consumers as problematic, or they're frustrated that they're opting in things, and they try to complicate their life by modifying the kinds of services that they provide. This is meant to prevent that from happening. However, let's jump down to this subsection C. Subsections A and B shall not be construed to require controller to provide a good or service that requires personal data from consumer that the controller does not collect or maintain. So this, what you're going to see in this set of subdivisions is trying not, to the extent that compliance with the other sections would actually require businesses to boost their information collection. It's not trying to encourage that. So it's calling out, if you need to collect additional data, basically, that's not what this is meant to do. And there's a piece about loyalty programs, which I'll get to, which relates to that retaliation against consumers. So this subsection, right there. Oh, thank you. Okay, I got it. Good. Okay.
Thank you, so helpful.
Shall not be construed to prohibit a controller from offering a different price, rate, level of quality or selection of goods or services to consumer, including an offer for no fee or charge in connection with the consumer's voluntary participation in a financial incentive program, such as a bona fide loyalty, rewards, premium features, discounted club card program, provided that the controller may not transfer personal data to a third party's program unless the transfer is necessary to enable a third party to provide a benefit to which the consumer is entitled, or the terms of the program clearly disclose that would be transferred. And it doesn't have to disclose that particular third party, it can be to a category of third parties. And the consumer consents to the transfer. So if as part of that voluntary loyalty program, the transfer is going to be disclosed, it can either be necessary to provide the benefit or clearly disclosed and consented to. The controller shall provide to consumers a reasonably accessible, clear, and meaningful privacy notice. So this is the whole mechanism for consumers to be apprised of what's going on with their data, to provide them with the mechanisms for enforcing their rights and be notified of potential enforcement. So the controller shall provide to consumers a reasonably accessible, clear, and meaningful privacy notice that A, lists the categories of personal data, including sensitive data controlled processes. B, describes the controller's purposes for processing the personal data. And you'll recall this links up to the data minimization piece that we were just talking about. Describes how a consumer may exercise the consumer's rights under this chapter, including how they may appeal a denial. Lists all categories of personal data, including categories of sensitive data that the controller shared with third parties. Describes all categories of third parties with which the controller shared personal data at a level of detail that enables the consumer to understand what type of entity those are, and to the extent possible, how they may process personal data. So you get a sense for who is this going to, and not just names.
Right.
Specifies an email address or other online method by which the consumer can contact the controller actively monitors. Identifies the controller, including any business name under which the controller registered with the Secretary of State, and any assumed business name that the controller uses in the state. Provides a clear and conspicuous description of any processing of personal data in which the controller engages for the purposes of targeted advertising, sale of personal data to third parties, for profiling programs and decisions that produce legal or significant effects, and a procedure by which the consumer may opt out of that type of processing. Again, that's that unique right under subdivision A6, and describes the method or methods the controller has established for a consumer to submit a request under that subdivision above. We do have some pieces that filled out what the privacy notice should look like. So under this subdivision 2, you'll see that the privacy notice shall adhere to the accessibility and usability guidelines recommended under federal law, the Americans with Disabilities Act, including ensuring readability for individuals with disabilities across various screen resolutions and devices, and employing design practices that facilitate easy comprehension and navigation for all users. The method or methods for submitting that request must take into account the ways in which consumers normally interact with the controller, the need for security and reliability, and the controller's ability to authenticate the identity of the consumer that makes the request. Provide a clear and conspicuous link to a website where the consumer or an authorized agent may opt out from controller processing of the consumer's personal data pursuant to that opt-out right, or solely if the controller does not have the capacity needed for linking. So certain businesses may not have these technological capacities. And for them, they can provide another method the consumer can use to opt out. So we're talking about methods for exercising rights, and allow a consumer or authorized agent to send a signal to the controller that indicates the consumer's preference to opt out of the sale of personal data targeted advertising by means of a platform technology or mechanism that does not unfairly disadvantage another controller, does not use a default setting, but instead requires the consumer or authorized agent to make an affirmative, voluntary, and unambiguous choice to opt out. I will note that this is an affirmative, voluntary, and ambiguous choice on the side of opting out. So this is unlike other consent mechanisms where you can think of it as, oh, we're encouraging a fulsome disclosures on the opposite side. This is not uncommon, but it's saying to opt out, you do have to make a deliberate choice.
Right.
But also have to be consumer friendly and easy for an average consumer to use. Is as consistent as possible with similar platforms, technologies, or mechanisms, and this goes to the informative piece.
Yeah. No.
Required under federal, state laws, or regulations, and enables the controller to reasonably determine whether the consumer's made a legitimate request, opt out. If a consumer uses a method to opt out of controller's processing of the consumer's personal data, and the decision conflicts with, and I hinted at this before, the consumer's voluntary participation in that loyalty program, the controller may either comply with the request to opt out or notify the consumer of the conflict and ask the consumer to affirm that the consumer intends to withdraw from that loyalty program. If the consumer affirms that they intend to withdraw, the controller then complies with the request to opt out, but there is that first piece in place, and that may be a clean case place to call it.
I think, so that takes us all the way to 24/20.
That's right.
Terrific, do this. This was terrific. Thanks. Anybody have, Monique, anything to end on?
I don't think so. I
Go ahead.
appreciate your walkthrough.
Yeah, no, it's a lot and my head is full. So but I'm excited at some of the few things I understood in this. I'm excited by some of the clarity which will bring for consumers on.
Right, it might be worth just talking about who we want to hear from, because we definitely wanted to hear from the state. I would
Yeah,
like to hear
I've got a
from,
whole list.
Okay,
which I-
controllers. yeah,
Controllers, Monique, you've given the list that we had, you have a terrific list of witnesses.
Yeah, there's
That includes everything, right? Controllers.
I have already put in some starting witnesses, some from their list that we have, and then some of people who've asked to testify for next week, and then we can go from there. But we'll be giving this another day for walkthrough and another half or full day for other witnesses.
Right.
Does the House speak with anyone about costs of compliance?
I would say broadly, the industry advocates, and obviously like those clients, did, I don't know that there was exact costs, but in general, it was a theme, yeah.
How many others?
15.
50, okay, so
Is
this
that what I?
Yeah, Kentucky just passed, has not had governor's sign signature
So that would
as
be
of
the
yesterday,
16.
that would be 15.
Yeah, and look, we have a great, I think that this is a good stopping spot. Let's give ourselves 7 minutes of break and come back if you would at 11. Where we will then say thank you to Kevin, our outgoing police chief and interim police chief, and welcome John.